Before we begin, remember that this video is for educational purposes only and isn't legal advice. Case summaries are meant to support your study, not replace reading the full case. Here's a case every law student needs to know for exam season. Have you ever thought you had a solid agreement, only for the other party to back out and claim there was never a contract? Today, we're looking at the landmark case of Gibson v Manchester City Council to understand the thin line between a binding offer and a preliminary discussion. Alright, let's start with the real-world problem. Understanding whether you have a binding contract often comes down to the first few steps of a negotiation. In the Gibson case, the council sent a letter saying they may be prepared to sell a house. This is what lawyers call an invitation to may help with, which is basically an invitation for the other person to make an offer. It isn't a binding commitment yet, but many people mistake it for a final deal. Knowing this distinction helps you avoid assuming a contract exists when you're still in the window shopping phase. The court focused heavily on the phrase, may be prepared to. This language is too tentative to create a legal obligation. If you're drafting an agreement or reading a proposal, look for words like offer, agree, or commit, versus propose, consider, or may. Using the wrong word can cost you thousands in legal fees later if the deal falls through. Mr. Gibson filled out a formal application to buy the house, but the court ruled this was actually him making the offer to the council. Just because you fill out a form provided by a company doesn't mean they have already agreed to the terms. Always check if the form states that the company reserves the right to reject the application after you submit it. Courts use a specific framework to decide if a contract was formed, and the Gibson case reinforced a very traditional approach. The House of Lords insisted on a clear offers and a clear acceptance. This is like a lock and key. They may want to match perfectly. If one side is still talking about possibilities, the key doesn't fit the lock. When you're negotiating, try to identify exactly which document is the offer and which is the acceptance. A lower court judge, Lord Denning, tried to look at the whole situation to see if there was a contract in spirit. However, the House of Lords rejected this, saying you can't just look at the vibes of the deal. This is a warning for business owners. Don't rely on a general sense of agreement. Make sure the formal steps are documented. For a contract to exist, the terms like price and subject matter may want to be certain. In Gibson, the council hadn't finalized all the details, which made the agreement unenforceable. Before you assume you have a deal, ask yourself, if a stranger read this, would they know exactly what is being traded and for how much? Quick reminder, this is a study summary, not legal advice. Always read the full judgment for complete context and nuance. The Gibson case happened because of a change in local government policy. This highlights how external factors can ruin a deal if you haven't locked it in. The council changed from Conservative to Labour control, and the new leadership stopped selling council houses. Because Mr. Gibson didn't have a binding contract yet, he lost the chance to buy. If you're dealing with a large organisation or government body, remember that their internal policies can change overnight. Speed and formalization are your best friends. In real estate, many documents use the phrase subject to contract. This is a safety net that prevents a binding deal until the final formal exchange. If you see this phrase, know that either party can still walk away without penalty. It's a common area where people overpay for legal advice because they don't realize they aren't actually committed yet. Mr. Gibson had already started improving the garden, thinking the house was his. This is a major red flag. Never spend money improving a property or an asset until the contract is fully signed and exchanged. You likely won't get that money back if the court finds that no contract existed in the first place. Now that we know what went wrong for Mr. Gibson, let's look at how you can apply these lessons to your own life and business. When you receive a proposal, ask the sender directly, is this your final offer that I can accept right now? If they say no, or if they say they need to run it by management, you don't have a binding offer. This simple question can save you months of uncertainty and potential litigation costs. Keep an organized folder of every email and letter in a negotiation. In the Gibson case, the entire decision turned on the exact wording of a few letters. If you're negotiating via phone, Always follow up with an email stating, "As per our conversation, I understand this to be an invitation to may help with and not yet a binding offer." If a deal involves significant money, like a house or a business acquisition, don't rely on your own interpretation of offer and acceptance. A solicitor or qualified professional can review the language to ensure you aren't accidentally binding yourself or leaving yourself vulnerable. It's much cheaper to pay for a contract review than a breach of contract lawsuit. The Gibson v. Manchester City Council case is a classic reminder that almost a deal isn't a deal. The big idea is to pay attention to the specific language used and never assume a contract is formed until there's a clear, mirrored offer and acceptance. Avoid rushing into expenses before the ink is dry. If this helped you understand the nuances of contract law, like and subscribe for more practical guides. We help you compare costs, understand the legal landscape, and make better decisions with confidence. See you in the next one. Remember, this is a summary for study purposes. Always read the full case. Thanks for watching. Remember, this is educational only. Read the full case and consult your course materials. Subscribe for more case summaries.